Factual, Hunt and another, and Annolight Limited and others.
Mr Marvin.
My Lord, sir. Yes, I appear for the appellant and my learned friend, Mr Aurora, for the first respondent, who was the third defendant, and my learned friend, Mr Denton, for the third respondent, who was the sixth defendant. As your lordships know, this is a second appeal with, obviously, permission of this court in respect of an order, though not expressed in these terms, taken to be a direction that Mr Sarwar of my client, the claimant's former solicitors, attend a hearing for cross-examination.
Sorry to interrupt you, but as you rightly point out, the order is not very pellucid in terms of its intended effect. Can I ask you this? Is it your understanding that the intent of the judge was that Mr Sarwar be cross-examined upon his witness statement, or was the judge intending to try and compel Mr Sarwar to give evidence, even if, hypothetically, the witness statement were to be withdrawn?
As I understand it, it's the latter, because the basis on which the judge, and I can go to the transcript momentarily if it would be helpful to your lordship, the basis on which the judge was requested to invite him to attend was not to address or to be tested on the matters in his statement. It was on the basis of a submission made by the sixth defendant, the third respondent, that he had failed to address in his statement a different matter and therefore needed to be asked questions on it. So the logic of that would suggest that your lordship's latter proposition is the right one. Would it be helpful to go to the transcript?
Well, it may do, and I don't want to take you out of your order, but your response to my question indicates that one of the matters we need to consider is to what extent Mr Sarwar is a compellable witness, even in the absence of any reliance upon a witness statement from him.
My lords, yes, that is the logic of it. That must be right, yes.
Yes, all right. So thank you for your answers. Please don't let me take you out of your work.
Well, my lord, not at all. It's helpful. It really does go to the core of this, that apart from all the objections one would have to a solicitor being tested in cross-examination on a wasted cost application, and I can go to the well-known authorities on that, the basis on which Mr Sarwar was asked to attend was that he hadn't dealt with a separate matter, and I'll come on to explain what that separate matter was, and that was a gap in his evidence that needed to be filled, and that's wrong for that reason as well, because he had chosen, as was his right, and indeed realistically as was his obligation, because as I will say, there'd been no relevant waiver of privilege, not to lead any evidence on that point. So the underlying claim, about which I really need to say very little, was by the claimant against initially 6, but it ended up being 3 former employers for noise-induced hearing loss. That claim was discontinued on the morning of the final hearing, which was the 12th of December 2019. I think Mr Justice Saini says it was the 13th of December, but it was the 12th. Nothing, though, turns on that. Can I, just by way of context, show the court the order that was made on that occasion? And your lordships have that in the supplementary bundle at tab 1, page 12. And the first point I need to draw attention to, and I will come back to this, is the third recital on page 12, that it's recorded that the claimant's counsel was informed by the claimant that he did not sign a Part 18 response dated the 9th of May. That's one of the issues in the applications that was subsequently made, and I will come back to show the court that shortly. And then the order that was made on page 13. The defendant paid the cost of the action. There were essentially two issues outstanding, because the claimant, of course, had the benefit of qualified one-way cost shifting. So the first issue is whether this order should be made to be enforceable against the claimant, and there are rules for that which aren't directly relevant for today's purposes. But the second issue was whether a wasted costs order should be made against my client, the claimant's solicitors. And the directions that the court gave, firstly, paragraph 2, whether determination of whether the cost order should be enforceable against the claimant, that's a reference to the Quox rules, and all should be paid by the claimant's solicitors. The term wasted costs isn't used, but that's obviously what it meant. Shall be made at a hearing before His Honour Judge Godsmark or his nominee. Any application with accompanying statements for the order, paragraph 1, be enforceable against either Mr Hunt or Walker Preston is to be made, etc. Then paragraph 4, and this is the starting point of the issues that arise in this appeal. Any response or responses to that application notice are to be made by way of witness statements, with a statement of truth to be filed, etc. Any witness statement from Walker Preston must be made by the supervising partner with conduct of the claim. So the judge there effectively mandated the form in which Walker Preston were to respond to any wasted costs application if they saw fit to respond at all, and he directed that any response be in the form of a witness statement made by the supervising partner.
So at that stage, he wasn't purporting to compel your clients to give written evidence.
He wasn't compelling that. He was, though, essentially saying that any response to the application had to be by way of a statement. But he wasn't. He left. I would accept he left silence an option. What I would suggest he didn't leave as an option.
Well, surely he wasn't intending to exclude the possibility of submissions. Surely he couldn't have intended to deprive your clients of the option of putting in no evidence, but to argue through counsel that the application should fail.
He may not. I mean, I would suggest it's possible to read the order either way. It's not central to what I'm going to say on this appeal, but he did seem to suggest it may not have been his intention. I can't dispute that, and no complaint was made against the order on that basis. Indeed, as your lordship knows, there's no appeal against that order at all. But it was capable of being read as any response had to be by way of a witness statement.
And it just as a matter of language, it's quite hard to avoid that conclusion, isn't it?
Well, my lord, yes, it is. But I mean, I'm conscious, firstly, that I'm not appealing this order.
No, I know.
But it's as a matter of language, it's hard to avoid that conclusion. But I understand my Lord Justice Arnold's point that it would be a surprising order for a judge to want to make, but it would not be surprising if the order was read that way.
I mean, I quite follow Lord Justice Arnold's point, but in terms of language, he isn't on the face of it leaving it open to you just to put in a document saying I dispute this.
This is misconceived in law, etc. As a matter of language, no, he isn't.
No.
As a matter of substance, he cannot have been intending that the solicitors should have be entitled to be heard in the absence of a witness statement. I mean, if you read it that narrowly, the only response could be a witness statement, and no submissions could be made about it. It can't have been his intention.
Well, I understand both points that are put for me. I do understand why it would be extraordinary for a judge to mean that, but I do just make the point as a matter of language. That seems to be what it says.
It does, yes.
So, but that was the order that was made, and we then come, if I can just, before I say anything more by way of background comments, to the actual order that is being appealed, and that's the order. In fact, my Lord, I'm sorry. In fact, I will take a slightly longer run up to the wicket, if I may, and come back to the order that's being appealed when I've just laid out the background. It's important just because, at least to save myself from muddle, if not anyone else, to be clear about the relevant parties. There were 3 remaining defendants by the time of trial: the 3rd, the 5th, and the 6th defendant. The 3rd defendant became the first respondent. That's Annolight, and they're represented by my learned friend, Mr Aurora, who sits next to me. They had a particular issue about whether the claimant had ever been a director of theirs, and it was said, although it was said that might potentially be fatal to the claim that he was making. There were arguments the other way that were never tried, The reason that's relevant for today's purposes is that in due course, a request for further information was asked and answered, and your lordships have that, and I'll qualify the word answered in a moment, but your lordships have that in the supplementary bundle tab 1 at page 34. And it's really, I really need go no further than the first answer, the first paragraph of the answer, where he said, I have never been a director of Annolight, and there is a signature on page 36, and that is the signature which, as your lordships just saw in the recital to the 12th of December 19 order, Mr Hunt in the end said was not his signature. So that's the disputed signature. And that was an issue that bore, at least in terms of the underlying claim, on the claim against the third defendant stroke first respondent, Annolight. There was a fifth, the next defendant was the fifth defendant stroke second respondent. They are not here today. They didn't participate in the appeal before the High Court judge either, and indeed they sent a letter saying that they didn't require Mr Sarwar to attend and they were neutral in respect of the appeal. I don't know if this court has had a similar letter that the High Court did.
I don't think we have, and I don't actually remember seeing that letter that was before Mr Justice Saini, but so they said that they were neutral and weren't going to participate.
And they're not here today.
Yes.
The sixth defendant is the third respondent, and that's Paragon Trades Limited. They're represented by my learned friend, Mr Denton, who sits to the right as I face the court, to the court's left. They also had a particular issue in the underlying claim, which was an issue over whether they had provided the claimant with ear protection. And I don't need to go into the detail of it, but it's outlined at paragraphs 9 to 12 of Mr Justice Saini's judgment, but essentially it was said that the claimant has said inconsistent things about whether or not it was provided. Yes, it was, no, it wasn't, and if it was provided, the use of it was not enforced. But there was a factual issue there which might have caused the claimant, if I can put it like this, difficulty or issues in cross-examination if the matter had gone to trial. But the detail of that issue isn't important. What's important to understand for today's purposes is that was an issue that related solely to the sixth defendant, and as I will come on to say, it's not an issue on which Mr Sarwar gave any evidence when it came to it. So those were the parties, and those two factual issues have a bearing on the matters before your lordships. With that background, what happened after the 12th of December 2019 order is that each of the three live defendants did indeed make applications, and all of those applications were two-pronged. They were to disapply quocs against the claimant and all for a wasted costs order against my client, Walker Preston. And I do want to show your lordships just how those applications were put. And this is also in the supplementary bundle. And I actually shown your lordships some of the documents that form part of the exhibit because that's where they are. But the application that was first in time was the third defendant or first respondents, and that's at tab 1 of the supplementary bundle. I don't really need to go to the face of the application. As I say, it was a two-pronged application. They all were. But I do just want to flag up the basis on which the application was put. And if I can ask the court to turn to page 5 of tab 1, and this is partway through a statement of Mr. Jonathan Mitchell of DACB, let me get it absolutely right, DAC Beechcroft Claims Limited, representing the third defendant. And at paragraph 8, at the bottom of page 5, essentially the way he puts it on the signature is if it wasn't signed by the claimant, then costs have been wasted. and if it was signed by the claimant, then he had been fundamentally
I'm
dishonest.
sorry, where are you looking at?
I'm sorry, it's paragraph 8
Yes.
on page 5.
Right.
So I was paraphrasing.
Is that not paragraph 12, rather? So on page 7, in the latter part of paragraph 12,
I'm so sorry.
if the replies
I
were
do
signed.
apologise, my lord. Yes, you're right. I was misreading my note. It is paragraph 12. I do apologise. It's the second part of that paragraph. If the replies were signed without the claimant's knowledge, then unnecessary time and costs have been incurred, etc., etc. If Walker Preston did not sign the replies, then these were signed by the claimant. Then the claimant has been dishonest, as documents show that he was a director.
But going back to paragraph 8, I
Paragraph
suspect that
8.
is the overarching.
The essential allegation against Walker Preston at paragraph 8 was that they failed to obtain proper instructions on the director issue.
So unless we're told otherwise by Mr Aurora, I take that to be the essential basis of the application for wasted costs by the
First respondent, that we had not obtained proper instructions. One thing, although Mr Sarwar does deal with it in his evidence, and one might say, well, it's the implication, as I will seek to show, no one actually alleged that Walker Preston had in any way been complicit in the forging of a signature. I can see why one might say, well, that might be what you would infer, but just to be clear, if it comes to a wasted cost application, that's not an allegation that's been made by any of them.
I might just flag now, for the benefit of Mr Aurora and Mr Denton, that I think we would like to know clearly and in terms, in the course of this hearing, whether it is alleged that Walker Prestons were complicit in a forged signature.
Well, no doubt my learned friends will answer that. I confine myself for present purposes to the observation that it hasn't been alleged yet. And it wasn't alleged in the material that was below. So that's the essence of the third defendant's application. I'm going to take them in order of time, which is the order they are in the bundle. So the next one that was made, that one was made on the 3rd of January 2020. The next one that was made was the 8th of January, which is the 6th defendant, 3rd respondent, so Mr Denton's client. And that's at tab 2 of this bundle. And I will try to do better with my paragraph numbering this time. On page, again, I'm going to jump into the middle of the 6th defendant's solicitor's statement. This is a Mr West of BLM. And paragraph 10, he says, he says, whilst it's a matter of public record that on the basis of the documents signed and filed at the Company's House, the claimant was or had been director of the third defendant, the issue of whether he instructed his solicitors to sign the Part 18 replies on his behalf is a matter on which I cannot comment further. He then says at paragraph 11, I have, however, since seen and read the witness statement of Jonathan Mitchell dated the 3rd of January and the exhibits attached. I seek to adopt those parts of his evidence which are relevant to the issue and application made by the 6th defendant. That's a slightly gnomic comment. It doesn't explain, at least not to me, which parts he's thereby adopting and saying are relevant, because that depends on how one understands the basis of the application. But he's certainly not seeking, if one takes those paragraphs together, I would suggest that the natural meaning of that is that he is adopting the complaint of failure to take proper instructions, because if one looks at paragraph 10, he's certainly not pushing the point about the signature on the Part 18 request.
Can we just pause there one moment? The complaint in the earlier application was a failure to take instructions on being a director.
Of
Yes.
the third defendant.
Of the third defendant.
Of the third defendant.
So why would that be relevant to the 6th defendant?
No, I'd see your lordship's point. But I'm not quite. I don't know what bits he's adopting. I mean, I don't want to be unhelpful. Perhaps it's not for me to try and. I mean, he seems to eschew anything to do with the signature. There was a more general complaint that I didn't go to directly towards the end of the third defendant's statement that Walker Preston failed to reply to correspondence. Maybe it was that.
Can we just suppose for a moment that what Mr. West has in mind is not merely that, but either failure to take instructions or on being a director, or very possibly the question of the signature on the response to the Part 18 request?
Well, it might. The reason it might be. I mean, my submission is it's not entirely clear. It might be the signature. The reason I'm suggesting that it doesn't really read like that is that paragraph 10 seems to want to say seems to be saying I'm not commenting on that.
Can I just flag up another point this time?
Of course, why not?
Definitely for Mr. Denton. So I think we will want to know whether the third respondent is alleging that the signature was forged. I think we will want to know whether the third defendant is relying on other parts of the first respondent's application. And I think we might want some explanation of how those matters could help the third respondent, considering that on the face of it they bear on the claim against the first respondent. And to make good a wasted costs application, you have to show that the misconduct affected you.
Causative, yes.
So I think we might want clarity on that point.
My Lord, I'm grateful for that. Unless there's anything else the court wants to ask me on that, but I can simply say the rest of the statement is about the inconsistencies in the claimant's case, alleged inconsistencies perhaps I should say, about whether hearing protection was provided and or its use enforced by the sixth defendant.
So just to be clear, we then get, as you say, paragraph 12, the other grounds arise by virtue of the facts and matters in relation to the issue of whether the claimant was or was not provided with hearing protection, and then we get set out the inconsistencies. Well, this is really a question for Mr. Denton again. Merely setting out inconsistencies doesn't amount to an allegation of misconduct such as could give rise to a wasted cost order. So I think we need to be absolutely clear what the allegation is, and that's something Mr. Denton will deal with in due course.
My Lord, yes. And then finally, there was an application by the defendant who didn't participate, as I said, hasn't participated in the appeals, the fifth defendant, the second respondent. Of course, your Lordships will understand we made that defendant a respondent deliberately because that respondent is affected and was a respondent below. So I hope that was the right thing to do, even though they declared their neutrality before this second appeal was launched. So that's at tab 3 of the bundle. The essence of the complaints there, which one starts at page 63, again jumping into the evidence at paragraph 10. There's what I would characterise as a general complaint that the solicitors, my clients, failed to obtain proper instructions at times, and then goes on to say, whilst the issue of whether the claimant is a director is a matter of the third defendant, it has a knock-on effect to the fifth defendant on the basis the claimant advises within his witness evidence that duties whilst employed by the third, fifth and sixth defendant were basically the same. I mean, I might suggest that's a non sequitur, but that's how they put it. I don't really see how the direct, if essentially the defence is you were a director, so you only have yourself to blame if the systems were inadequate. I don't see how that does help, but be that as it may. And then the further complaints that made at paragraph 14 and 15 were a failure to reply to correspondence and not being available on the day of trial. So those were the allegations as put. And before the matter returned to the circuit judge, Mr Sarwar of Walker Preston filed a statement that your Lordships have at the next tab, tab 4. And paragraph 3, Mr Sarwar says in terms, this statement is limited to dealing with the third defendant's application for wasted costs against the firm. The wasted cost order is sought on the basis the firm failed to take proper instructions from the claimant on the issue of whether he was previously a director, and as such the claim should never have been pursued or should have been discontinued as having no merit. He then says at paragraph 5 it's important to distinguish between two matters: the claimant denying or failing to accept that he was a director, that's the first matter, and the second matter is whether his having been a director, if that had been the case, meant that the claim had no merit. And he says at paragraph 6 it's only the latter of those two that he will deal with. And he, in subsequent paragraphs, makes an argument as to why a finding of directorship wouldn't have been fatal to the claim. Before we get to that, he says at paragraph 8 he is limited in addressing the matters which are clearly privileged. Although it hadn't, I have submitted, been alleged, at least not expressly, at paragraph 12, he did deny, he said that he understood that it had been implied that the firm involved itself in some shape or form to have forged the signature. He said at 13 that's categorically not true, and at 14 he said that the claimant had signed electronically. And that the rest of that, the statement is really concerned with saying why, even if it was found that the claimant was a director, that wouldn't have been fatal to his claim. He did not, just to be clear, he did not address at all the alleged inconsistencies in the evidence about the sixth defendant's provision or enforcement of use of hearing protection. And if I may say, it's easy to understand why not. There had not been, other than to the extent that one might say the recital to the judge's order and the claimant through counsel denying he'd signed the Part 18 request, there had been nothing that could be taken as a waiver of privilege. So that is how it was when the matter returned before the circuit judge. There was a later statement, a letter from the claimant himself, that your lordships have at tab 5, but that was not before the circuit judge. That came, it was certainly not before the circuit judge, and so far as one can see from the date stamp on page 78, it was not created until after the hearing that I'm about to go to before the circuit judge. And it may well be that it was created consequent upon what happened at that hearing. So I will come back to that, but I will. It may be clearer if I deal with it in chronological order. So I will come back to that, but I will now turn to the hearing, which is the subject of now this second appeal before the circuit judge. And can I start with the order that the judge made? And that's in the main bundle at tab 15. Page 241.
It doesn't look like 241, at least in my bundle.
Oh,
241 is partway through the transcript.
Is it 229? I'm sorry. I think
the order is 229.
229. I'm sorry. I think
there are rival systems of numbering.
There were. I think what happened, and I apologise, this may not have been the most helpful thing to do, is because there were extra documents, we and I hold my hands up to this, filed a replacement bundle. That was at the invitation of the court, but what was done, and I apologise that this probably wasn't very helpful, is it changed all the page numbers because it added documents at the beginning. So I have both page numbers, so if the court's working from a bundle where it's 229, I will adhere to the old.
Well, I'm working from the electronic bundle, in which it is 241.
I will.
The updated.
I'm so sorry about this. I can give both page numbers. I mean, I have them both marked up. So
What just causes me a slight alarm is to confirm what's at the beginning of the revised bundle.
What was added? Let me deal with that. What was added was the orders your lordship made granting relief from sanction to each of the two active respondents to rely on the skeletons below.
Yep.
What was then added further on was their skeleton arguments from below. In fact, so I'm so
Yes,
sorry.
yes.
One was in the bundle already,
Yes.
I think, and the other one was added to the bundle.
Yes, I see.
And then in the supplementary bundle, while I'm dealing with this at the end, although I don't think we need to look at them today, their applications to the court for relief were added.
I see.
But I don't propose to turn to them today.
Thank you very much.
So there's no if it's just to reassure the court, there's no underlying material that's different between the two bundles. It's simply the court's orders and the skeletons from below.
Yeah.
But I do apologise. I do realise it wasn't the helpful thing to do to send an entirely new bundle with a different set of page numbers the day before the appeal, and I apologise for that. So on page 230 or 242 is the order itself, or the order. It starts, and I just mentioned this in passing, it seemed to be accepted before the circuit judge that Walker Preston needed to be added. And for what it's worth, that's not necessary for a wasted cost application, but there it is. It probably does no harm, but it wasn't needed. But it's not a non-party cost application or anything like that. But the important bits are just to, that there's directions for, because at this stage Walker Preston, my client, hadn't come off the record for the claimant, so there were directions in respect of getting on with that. And as we will see when we come to the transcript, the judge was understandably concerned that the claimant wasn't there or any longer really being represented by my clients and possibly knew nothing about the hearing of the application. So he made the direction at paragraph 4, the time for the claimant to provide the court and the defendants a witness statement or letter is extended to the 29th of May. Such witness statement or letter should comment upon the witness statement of the hearing bundle from Mr Mitchell, Mr West, Mr Bloomberg and Mr Sarwar. And then, although we didn't put in a further statement, paragraph 6, any witness statement from the 7th defendant in response to that of the claimant should be filed by then. And then, although it wasn't expressed in terms of cross-examination, it's how it's been understood, and it's how Mr Justice Saini understood it, and it's apparent that there was the hearing, the 3 applications is adjourned to the next available date in September 2020 before Judge Godsmark, when oral evidence will be heard. It doesn't say so in so many words, but it was clear from the transcript that it was requiring Mr Sarwar to attend.
Even if he didn't put in a witness statement?
Well, your lordship's put that to me, and my answer is yes, that's the logic of it. That's how I would interpret it, given that the basis on which it was requested and granted was that Mr Sarwar come to be asked questions about the hearing protection on which he hadn't given any evidence. So it wasn't actually canvassed before the judge what would happen if he withdrew the statement he had put in, for example. But the logic of the judge's approach...
Well, he hadn't put in a statement at that stage. The statement came later, didn't it?
No, my lord, the statement, Mr Sarwar's statement, it has the wrong date on it. The statement is January.
Yes, of course, I've forgotten that.
And it was in, and that's the reference in paragraph 4 to the statement of Mr Sarwar. There's only one statement from Mr Sarwar, and it's the one your lordship's seen.
In which case, what was the function of paragraph 6?
Well, it was anticipated the claimant might put in evidence or a letter, and Mr Sarwar...
right, so there might be responsive. Okay, I see.
It says, yes, in response to that of the claimant. That of the claimant is a reference to what's at paragraph 4.
Thank you.
So I will come now to the transcript of this hearing before the circuit judge, Judge Godsmark. That's at tab 16. And I don't need to go to the earlier part in any detail, but the judge quite understandably raised the concern that Mr Hunt wasn't there and wasn't represented and may not know what was being said, and essentially said, well, we need to do something to have him properly engaged in this process. And I can pick up the story at page either 235 in the old bundle, 247 in the new bundle, which is page 5 of the transcript. And this is where the judge, and it's right to flag that the issue of the attendance and cross-examination was raised initially by the judge, not by any of the parties. And so just to read from the beginning of what the judge says on page 247.
So just to be clear, the judge had before him no application notice by any of the defendants seeking an order for
No,
cross-examination?
there was no application at all. No application. The only applications were the ones I've shown your lordship, although I skimmed over the face of them. They simply asked for wasted costs. There was no application for directions.
I mean, I suppose
For compelling cross-examination.
I forget how the earlier order was framed, but the idea was that there would be a hearing at which the judge gave case management directions
Yes, that's
for
that.
the determination.
There was. He made that. That's fair. He did, but there was no indication, as my Lord Justice Arnold said, there was certainly no application for cross-examination of the solicitor. And indeed, your lordships will know that, at least as a general matter, and I hope strain to controversy when I say that, it is, to put it as low, as highly unusual for a solicitor to be cross-examined on a wasted cost application. So the judge starts by saying it's pretty well the position I thought we were in. That's a reference to the problems with Mr. Hunt not being engaged in the process. He then says to my predecessor, now Mr. Trevelyan, I know you may not be in a position to assist greatly, but it seems to me Mr. Hunt needs to be engaged in this process. And there is every indication at the moment he's certainly unaware of the applications that have been made, or he may well be unaware of the applications that have been made that affect him or today's hearing. Now, that may have certain consequences for today. I understand that to be a reference to costs, but in the end the judge reserved costs. But can I take this one step further? Do I take it, or can I ask, is it anticipated that Mr. Sarwar will be required to attend for cross-examination? And the judge then turns to the defendants. He turns first to my learned friend, Mr. Aurora, the third defendant, first respondent. Mr. Aurora doesn't, to be fair to him, he doesn't absolutely say no, but he certainly doesn't urge this upon the court. He says, I think my learned friend, Mr. Denton, has stronger views on that than I do, Your Honour. The position I was going to propose was to say, well, if this is adjourned today, it's adjourned at Walker Preston's costs because of their failures. The judge says, I'll come to that, Mr. Aurora, and then he says, what I want to know at the moment is, do you require him for cross-examination? And Mr. Aurora then says, I think I would be prepared to deal with this without him being present, but as I said, I think Mr. Denton, my learned friend, has stronger points to put to him in respect of what was said to the medical expert. That's a reference to the medical expert being told different things about whether or not the claimant was a director of the sixth defendant. One of the reports recorded one thing and one recorded another. I'm so sorry. No, I'm sorry. Forgive me. That was completely wrong of me. It's a reference to what he said to the medical expert about the provision of hearing protection. Yeah. I'm so sorry that I'm getting myself muddled about the different defence. I do apologise for that. He said different things on the face of the two different reports. And Your Honour, I think Mr. Denton wishes to address you on that. Then the judge turns to Lady Tripper, who was representing the passive respondent, the fifth defendant, second respondent. Do you require Mr. Sarwar to be present? And then Lady Tripper says, no, Your Honour, my position is rather different. D3 has the issue about fundamental dishonesty in relation to answers to questions. D6 has the issue in relation to a change of what's contained in the medical report in relation to ear imperfections. Yes. And I think this must be an error in the transcript. The transcript shows this next remark by Mr. Denton, but I don't think it can be, because 3 lines down, Mr. Denton says something quite different, having been called on by the judge. And I know my learned friends were there, and they may be able to help the court on this. I don't think it was Mr. Aurora either, because it refers to D3, and it looks like it's not the person representing D3 who's saying this. So I think this must have been Lady Tripper again. Although the first point for D3 is fundamental dishonesty has some knock-on effect to me on causation, so that can't be D3 speaking, I don't actually require the presence of Mr. Sarwar. My position is submissions. I think that must have been Lady Tripper saying that. It's unfortunate that there was a slip just there, but there it is. Then Judge Godsmark turns to Mr. Denton and says, it sounds as though you do require Mr. Sarwar. So my learned friend, Mr. Aurora, has given the build to this. And Mr. Denton then says, Your Honour, yes. You will note the sixth defendant's application, which appears at page 89 of the bundle. And whilst we adopt the position taken by the third defendant, there is an issue concerning the medical reports of Mr. Zaiton, and you will note, Your Honour, that whilst the claimant's solicitor, Mr. Sarwar, has produced a statement dealing with the third defendant's application, the witness statement is silent as regards the points made in the sixth defendant's application. That must be a reference to the hearing protection. Judge Godsmark says yes.
So just pausing there, that seems to be an application by Mr Denton for the opposing solicitor to be compelled to give evidence, and moreover compelled to give evidence on a topic which prima facie is covered by privilege.
Precisely, yes, indeed. My lord, I say it's just that. And then Mr Dennis says, which to a certain extent, Your Honour, is inextricably linked to both the question of fundamental dishonesty and or, well, I don't know about that, and or whether the claimant's solicitors ought to be paying the costs. And then the judge says, so the position is that even if Mr Hunt himself decides to play no further part in this matter, we're going to require some live evidence in any event. If Mr Hunt does participate in this, there's perhaps going to be a little more live evidence than would otherwise be the case of the questions of waiver of privilege. Your Honour, yes. So the direction that must be, I think, what I need to do to is the direction that would assure an opportunity for Mr Hunt to become engaged and look for a hearing date, etc., etc. So that's the basis on which the request for cross-examination...
Do we just need to see what Mr Trevelyan said at the bottom?
We do. I mean, I know
you're coming back to that, are you?
No, let me deal with it now. I mean, it's not... I do appreciate that it was not handled as well as it might have been by counsel who was appearing for Walker Preston. I mean, the first point I would make is he may have been surprised by all this. The second point I would make is that although the judge on the first appeal, and I'll come to this, says he's being generous in letting the arguments in, the point is that the judge on the first appeal did decide it on the merits, and there's no respondent's notice saying he was wrong to do that. And indeed, one of the skeletons before him did, by my learned friend Mr Aurora's skeleton, which is in the new bundle, if not the old bundle, did actually make the point that this was a new point, although he didn't say it shouldn't be entertained. He said it was relevant to the review of the discretion. So the judge had that point in mind, Mr Justice Saini, I mean when I say the judge. But I do accept that it was not as well dealt with by Mr Trevelyan as it might have been, and it would be facile of me to pretend otherwise. So yes, and I come to this. So I simply pause there and say that's the basis on which it was put to the judge. And in fairness to the judge, he did then turn to Mr Trevelyan, who said this at the bottom of page 248 or page 236. Your Honour, only that I agree with Your Honour's proposed way forward, I could say that I did have some concerns regarding reading the third defendant's application, and I hear, of course, what my learned friend, the third defendant, now says. But the third defendant's application in turn would always have been for a trial on fundamental dishonesty, and at which at least Mr Hunt, it seems to me, or possibly Mr Sarwar as well, would have been required to give oral evidence in any event. So I did have some concerns about whether this was a matter that could be conducted today anyway. But I hear what Your Honour says, of course. And that's what he says, and I accept that it would have been wiser for him to have protested about what was being suggested about Mr Sarwar, of course. And
so he's making the particular point that he worried about whether it could be wrapped up that day.
That's because everyone started the day on
the basis of
it might be wrapped up that day.
But in that context, he says, well, I always thought there might be oral evidence, including from Mr Sarwar.
Possibly from Mr Sarwar. But again, this may not mean that it was the right point to make, but it takes it away from the wasted cost issue. He was focusing there on the fundamental dishonesty application. I mean, I will come on to say, although, that if the purpose of if the other purpose, and this wasn't how it had been put to the judge, but if the other possible purpose of cross-examining Mr Sarwar was to shore up an allegation that the claimant had lied, that would be highly questionable of itself. But that isn't how it was put to the judge. To put the former solicitor in the box, to help establish, to ask him questions, when he certainly hadn't on the fundamental dishonesty application given any evidence in support of his client. He wasn't his client's witness for that purpose. Would have been highly questionable. But what this really shows is Mr Trevelyan thinking aloud and perhaps not thinking as well as he might have done on more careful reflection. But I accept that was not his best moment. So that, unless there's anything else, Your Lordship, wants me to deal with in the transcript. That's the nub of the transcript dealing with the oral evidence issue. Before we come to the High Court judge's judgment, I said I would come back to the document that came in subsequently because it's helpful, I hope, for the court to see this because Mr Justice Saini does refer to it. It's at tab 5 of the supplementary bundle. And I hope everyone has, the whole court will have the same page numbers here because the new pages are added at the end of this bundle. So it's tab 5, page 78. This looks like this must be a handwritten note from the claimant. Please find enclosed a copy of statements sent to His Honour Judge Godsmark QC, Nottingham County Court, who stated it should be sent to all other parties in this case. P.S. Also, could you please pass on my file as requested to Admin Injury Law Chambers? Thank you, John Hunt. And Mr. Hunt's letter that was sent to the court, it would seem in response to the order that Judge Godsmark made at the hearing that your lordships have just been looking at, is at pages 79 to 80. I don't know if your lordships have had a chance to look at this. There are two broad themes before I jump to the specifics in this letter. One is dissatisfaction with Walker Preston. The other is the claimant's most unfortunate personal circumstances. I don't propose to say much about either of those, but between those two, beginning at the second substantive paragraph on page 79, there's reference to documents and signatures. And to be clear, I don't know anything, and I'm not giving any evidence beyond what's in this document, but on a careful reading of this, he's not actually talking, I would suggest, about the signature on the Part 18 request. He's saying that there was another document, and it would seem what he's saying is that someone at Walker Preston questioned the authenticity of the document that seemed to suggest that he was a director. And I draw that point out because we've been talking about one question signature, and it seems to me that this letter's not talking about that signature.
I assume it's talking about
one.
what is to be found at Company's house.
Yes, it seems
which was the basis of the Part 18 request in the first place.
I mean, what he says is so it's the second large paragraph. Walker Preston have always been privy to all documents and information relating to my previous employment and have never given me reason to believe that there were any discrepancies within any of it. Ian Meachan of Walker Preston has drawn to my attention a signature that was on a document. He questions its validity and told me that he thought it was a forgery because it didn't match my signature. The document was one that I had allegedly signed, which made me a director of the firm National Glass. At the time the document had been signed, I had lost both my parents and sister to cancer. My marriage was breaking down, and I was faced, I think that should be forced, it says, with the prospect that I would be possibly losing my house and residency of my child. I was suffering extreme stress and cannot recall signing any such document and have never stated anything to the contrary. Never was this document or my signature honoured, and issue Walker Preston with regards to how successful they thought my claim would be. And then I also think, just read the next paragraph. When I attended court in December 2019, the barrister representing me had been ill prepared by Walker Preston. I was told that she had been given little information into the case and that she wasn't even aware that there had been previous adjournment. It was the opinion of those present at court on the day that my case had been badly handled and that Walker Preston had been negligible, the word used. And then he goes on to say he had received advice. I received advice notifying me that I wouldn't be successful, so contacted Walker Preston's, telling them that they would not be representing me further following the signed director document being in existence. And then it goes on. I don't think I need to read any further. So, as your lordship anticipated, it's a different document he's talking about. He doesn't actually repeat the allegation recorded in the judge's December 19 order that the signature on the request for further information was not his. I'm not saying he dissociates himself.
No, I mean, I suppose it's conceivable that there was a misunderstanding there. No one said this, but it is conceivable that actually what he said to counsel on the day was...
Yes, no one... I suppose it is that he was actually telling counsel about a different document.
Yes.
Well, that's not what counsel said to the court.
No.
I mean, I'm not in a position to go behind that. And no one said subsequently
No,
that a
no,
mistake was made, but I suppose that's possible. And he doesn't obviously make any direct allegation. I mean, he makes criticism of Walker Preston. I don't duck that, but he doesn't, as I say, he doesn't say Walker Preston must have signed this without my authority or anything like that. He's talking about a different document altogether. And I mentioned that in the chronology. That wasn't any part of the circuit judge's decisions and directions because this post-dated that hearing, but it is referred to in the judgment of the High Court judge, to which I will now come. And the judgment is in the supplementary bundle, forgive me, the main bundle at tab 9. And it begins either at page 32 in the old bundle, 36 in the new bundle. There is a lengthy and careful recital of the history of the matter, and I don't really need to go to that at any great length. The key to the judgment is paragraph 46, but before I go directly to that, I just want to refer to paragraph 27, which is on page 36 of the old bundle and 40 of the new bundle. The judge says, having gone through the history of the matter and referred to the hearing, he says, for completeness, I should record that before the CMC, Mr Sarwar had provided a witness statement which explained the firm's position in relation to the Part 18 responses concerning the directorship. In that regard, brackets, although he was at that time constrained by privilege, the essence of Mr Sarwar's evidence was that the inaccurate Part 18 response in relation to the director of the third defendant was in fact signed by Mr Hunt. Notably, however, Mr Sarwar did not deal in any way with the substantial other, which was the confused and contradictory position put forward on behalf of Mr Hunt in relation to the hearing protection or lack thereof provided by the sixth defendant. The reason I just go to that is that parenthetic phrase, although he, that is Mr Sarwar, was at that time constrained by privilege. Nothing had happened in relation to waiver of privilege, except insofar as one regards the letter from Mr Hunt that I've just shown the court as somehow altering the position. Mr Sarwar had certainly not explicitly waived privilege, and his letter didn't... Mr Hunt had not explicitly waived privilege. Sorry, it's Mr Hunt's letter I meant to refer to if I said Mr Sarwar.
No, you said Mr Hunt's letter, but you said Mr Sarwar hadn't.
Yes, Mr Hunt hadn't explicitly waived privilege. Every indication is he wasn't at that stage being advised. There might have been an argument, I suppose, as to whether there was an implied waiver of privilege of any sort. But the highest that could be put is dealing with this, is the directorship issue. Mr Hunt's letter didn't discuss the hearing protection provided by the sixth defendant. And even if he had said, well, my case is such and such, that wouldn't amount to a waiver of privilege. So it's a little unclear why the judge qualified the reference to, at that stage, being constrained by privilege. And that has some bearing on understanding what I say is the key paragraph of his judgment, which is paragraph 43. Before I turn to that, I mean, it is, your Lordship rightly raised with me the way that it was put by counsel at first instance when the issue was raised. It is right to say that the judge, he said he was being generous, but the fact is that he dealt with this on the merits. There was actually some pushback from the first respondent against that, who cited the authorities about new points on appeal and reviewing discretion on matters not before the judge. So the point was live and he decided this was the right way to deal with it. I say in justice that was right, but also if I can take a forensic point, there's no respondent's notice saying he was wrong on that. So this court's appropriate approach, in my respectful submission, is to deal with the matter on the merits, because it was dealt with by the High Court judge on the merits. And also, and your Lordships, particularly my Lord Justice Arnold, have already put to me, really the unsatisfactory way in which it emerged at first instance. It may well be counsel was just completely surprised by this. There was no forewarning of this when it was raised by the judge. So I'm not going to deal with the crucial point, and is at paragraph 46 of the judgment. So perhaps I should, having said what I've just said, show the court paragraph 45 as well. Page 43 of the new bundle, 39 of the old bundle. He says, having been judge of the firm, I've considered the matter essentially de novo, based on the facts which have been argued before me. As I shall explain, I have no doubt that it is a proper exercise of discretion to require Mr Sarwar's attendance. And then the judge says at 46, a number of matters are particularly relevant. First, the firm is no longer acting for Mr Hunt. Well, that's a fair observation. They come off the record by then insofar as it goes, but I would suggest it doesn't take matters any further. That won't untypically be the case in a wasted costs by the time a wasted costs application is heard. Second, it appears to be the case that privilege has been waived and there is no restriction on the firm giving a full account of the position between itself and Mr Hunt. If that's on the directorship issue, I can understand why the judge is saying that, but if it's on the hearing protection provided by the sixth defendant, I don't understand why the judge is saying that. And insofar as he's saying there's been a broad waiver of privilege, that can't be right. There's just no basis for that. And of course, the other point that bears noting is that clearly Mr Hunt did not have a solicitor writing on advice, my client waives privilege. If it's being said that Mr Hunt perhaps inadvertently had ended up waiving privilege, that was a matter on which surely Mr Hunt should have been heard. And as the judge records, and we'll see this in paragraph 48, Mr Hunt, because of an unfortunate regrettable he hadn't been shown at the listing change, didn't come until the end of the hearing. The judge very properly and helpfully explained to Mr Hunt what had happened. But he clearly didn't consider himself to have done anything that was determinative of any of Mr Hunt's rights in the judgment he had just given, because he ends by saying he will have his chance when the matter returns to the circuit judge. So to make sense of his second, that has to be, although the words are, if the words are wide, then respectfully the judge is wrong. And if the words are narrow, then it has no bearing at all on the sixth defendant of the hearing protection issue. And then he says, third, it's clear to me, even on a brief perusal of the witness statements, that there are radically different accounts given by Mr Sarwar, the firm, and Mr Hunt as the facts which are central to certain of the issues to be determined by the judge on the hearing of the defendant's application. Well, that meant, I take that at least in part to be a reference to Mr Hunt's letter that wasn't, of course, before the circuit judge. But there aren't really these radically different accounts. The reality is they're talking about different things. And of course, neither of them says anything about the hearing protection, which is the issue on which was the basis on which Mr Sarwar's attendance was required by the sixth defendant. So there were no different accounts there at all. And then he says it may well be that it is rare to require the attendance of a representative to be cross-examined on an application of this type, but in my judgment, it's difficult to see how these issues could be resolved in a fair and proportionate way without the oral evidence from Mr Sarwar. Well, I'll come back to that in just a moment, because I say that represents an error of law. That's essentially the conclusion that although it's rare, on the facts here, in order for there to be a fair determination, there has to be oral evidence from Mr Sarwar. Fourth, I'm confident that the nature of these issues is that they can be managed in accordance with the overriding objective so as to avoid the hearing of the applications becoming a substantial piece of satellite litigation. I mean, that may be optimistic, but it's not central to my appeal to challenge that perhaps optimistic view of how this will turn out.
Is it your submission that when, going back to the previous point, he says it's difficult to see how these issues could be resolved in a fair and proportionate way without oral evidence from Mr Sarwar, you're proceeding on the basis that Mr Justice Saini, like the circuit judge, was purporting to say that Mr Sarwar was a compellable witness at the instance of the sixth defendant, even apparently if his witness statement was withdrawn.
So it would seem, yes. I mean, the judge doesn't distinguish between if he's talking about the director issue or whether he's talking about the hearing issue. But it would seem that I mean, I'll address both possibilities. But it would seem that he's talking about the hearing protection issue. But there are, at least in part, there are other parts where he's talking about radically different accounts, which I don't think that can be the hearing protection issue, because there weren't any different accounts there. That must be the signature, the directorship issue. But again, there aren't really, on a careful inspection, there aren't different accounts there. There is Mr Sarwar saying, we didn't forge this, and Mr Hunt either saying, it wasn't my signature, or saying, he was, or talking about a different document altogether on which it was suggested his signature had been forged.
Can I just clarify one point? Assuming somebody had a discretion as to whether or not to order cross-examination, is it Mr Justice Saini's exercise of discretion we're concerned with? I mean, he says in 45, I've considered the matter essentially de novo. I have no doubt it's a proper exercise of discretion. So are we dealing with his exercise of discretion, or are we dealing with Judge Godsmark's exercise of discretion?
Ultimately, I'd say your lordships are dealing with Judge Godsmark's exercise of discretion, because the underlying question on a review exercise of discretion, on an appeal on an exercise of discretion, the ultimate question is whether the judge exercising the discretion has exercised it right. And I would say the fact that he says essentially de novo, that I would say that the fact he was essentially letting in new points on an appeal, if that's how it's characterised, doesn't alter the proposition that the question for the judge immediately below was whether the circuit judge was within the scope of his discretion.
Yeah.
But even if I'm wrong on that, and it's a question of reviewing the High Court judge's discretion, I would say that was flawed. I mean, the judge, insofar, and again, it seems to be the way it was put by the sixth defendant to the judge, and my learned friend obviously relies on that skeleton again today. It seems to have been put again on the basis that Mr. Sarwar had failed to deal with certain matters. And I know it's always an invidious thing to do to go to one's learned friend's skeleton, but and also it's doubly invidious because I think it may not be in my Lord Justice Newey's bundle, but I know my Lord.
I do have the skeleton.
But in the new bundle, it's at tab 12, page 183.
I don't have it in that form, but I do have all the skeletons.
And in particular, paragraph 9.
Can I just check which one you're referring to? This is Mr. Aurora's skeleton before Mr. Justice Saini.
No, I'm sorry, it's Mr. Denton's skeleton.
Mr. Denton.
Mr. Denton's skeleton, which he also relies on for today.
Yes.
And it's paragraph 9, which in the new bundle is page 185. And again, it's put, speaking of himself, counsel for the sixth defendant indicated that he's speaking about himself there, 29 indicated that given that the state was silent on points raised in the sixth, that should be sixth defendant, not sixth respondent, application oral evidence would be required. The learned judge acceded to that. So the judge's decision was being supported by the sixth defendant on the basis that Mr. Sarwar was required to give evidence on matters he hadn't given evidence on in his statement. So I do say that whichever judge one looks at, they were wrong in principle. Each of them was wrong in principle to require Mr. Sarwar to be cross-examined. Firstly, and I will come to the authorities on this, it was wrong in principle to require a solicitor respondent to a wasted cost application to be subject to cross-examination. Secondly, although I take on board the points your lordships have made to me about why it would be astonishing if the judge meant to debar submissions, it was wrong to use a statement that effectively the judge had required to be the form in which an application was responded to as a basis for ordering attendance.
Sorry, complete your point, and then I'll just comment.
And thirdly, it's wrong in principle to order Mr Sarwar to attend so that he could be asked questions about matters that he had not addressed in evidence and which it would seem, in my submission, remained covered by privilege. Fourthly, if it is the case that the contrary to what I've said, that the reason or a reason Mr Sarwar was being required to attend was to press him on the signature for the request for further information, then if that were the position, then that would also be wrong. It would be wrong effectively to compel Mr Sarwar to attend to effectively, it would be hoped, help establish an allegation of fundamental dishonesty against his former client. So for one or more of those reasons, I say that each of the judges and whoever's discretion one looks at was wrong.
I know you're going to develop these points, but just as to your second point, you say, well, the judge had effectively required the statement to be the form of the response. I mean, if Mr Sarwar saw things that way, then it was a surprisingly limited document, because he did only deal with one point, and he didn't put forward his submissions in answer to the applications.
Well, I take on board your lordship's. I wasn't actually, your lordship's right to press on this because I said what I had to say about that before, so I wasn't actually going to come back to it. But it's not my main point on this appeal. But it's an unhappy, if I may respectfully say so. And I do understand the points, both that it would be an extraordinary thing for a judge to direct, but also looked at on the words, it seems to be what it meant. But I do recognise the point also that Mr Sarwar didn't deal with other matters. But of course, there's no evidence from him as to why he didn't, but the obvious answer on the hearing protection is that he would quite rightly have regarded all that as privileged. It might also be that he regarded it as a hopeless basis for a wasted costs application that his client had given inconsistent answers, but there we are.
Sorry, can you just remind me where Mr Sarwar's statement is?
Mr Sarwar's statement is in the supplementary bundle at tab 5.
4. Yes.
No, sorry, tab 4, forgive me. It's Mr Hunt's letter at tab 5.
I was just reminding myself what he said about why he was making the statement. So
yes, that's paragraph 3. And
paragraph 3, I make it pursuant to, which is perhaps not particularly helpful either way.
No, it doesn't.
What he thought.
He doesn't say. He doesn't.
It doesn't say he's
be
obliged
in
to.
Compliance.
It
doesn't say yes. It could be in compliance with the deadline. I accept you can't. I wouldn't try to read into that because I've been told I have to.
It doesn't really.
I mean, had he thought that Judge Godsmark had required him to put his whole case in this witness statement, well, he's got a very limited case.
Yes, but he couldn't really have. I mean, all he could have said on the hearing issue is, "I'm constrained by privilege," and he didn't specifically reference the hearing protection issue when he referred to privilege, but he did say, and of course he was right, that he was constrained by privilege.
Yeah.
So, I know your lordships. I'm going to turn now to some authorities. I know your lordships will be familiar with the rule. But just so your lordships have it, and I apologise for the typographical error in my skeleton, it's Rule 46.8 on page 1606 of the White Book. That's the rule about the wasted costs applications. And sub-rule 2 that's been referred to, the court will give the legal representative a reasonable opportunity to make written submissions, or if the legal representative prefers to attend a hearing before it makes such an order. But 46.8 simply sets out the rule, saying that the basis of the wasted costs application. In terms of what's expected, there's a bit more in the practice direction. It's not directly relevant for today's purpose, but I will just show the court it for completeness. It's essentially, if I can put it this way, it's essentially a codification of the principles one finds in Ridehouse primarily, but also elsewhere. And one has that at page... So sorry, it's page 1625. And so 5.5, it's 5.4 is you apply by notice or by making an application orally. 5.5, it's appropriate to make one if the legal representative has acted improperly, unreasonably, or negligently. 5.7 says in general there are two stages. 5.8 that the court only proceeds to the second stage if it's satisfied. The second stage doesn't proceed to the second stage without giving the legal representative an opportunity, and that really reflects basic principles of fairness that are set out in Ridehouse. It doesn't specifically address the issue of cross-examination, perhaps because it didn't I would suggest it didn't really occur to the rule makers that was be a live issue, and it wouldn't have done because the authorities are very clear on this in my submission. And so can I go to the extremely well-known case of Ridehouse, which your lordships have in the authorities bundle, and here I hope there is only one version of the bundle, and Ridehouse is at tab 1. As your lordships will know, this is the leading or a leading body and authority on wasted costs, and is probably cited in every case where wasted costs are contended for. It is very well known, and I don't propose to go through it at any great length unless that would be helpful. The guidance, and Lord Bingham MR was clearly giving general guidance on this. A number of cases have gone up to the Court of Appeal to sort this jurisdiction out. And the key passage, which is sidelined at page 238 of the report, is on procedure. And his lordship says this: the procedure to be followed in determining applications for wasted costs must be laid down by the court so as to meet the requirements of the individual case before them. The overriding requirements are that any procedure must be fair and that it must be as simple and summary as fairness permits. Fairness requires that any respondent lawyer should be told very clearly what he is said to have done wrong and what is claimed, but the requirement of simplicity and summariness means that elaborate pleading should in general be avoided. No formal process of discovery will be appropriate. We cannot imagine circumstances in which the applicant should be permitted to interrogate the respondent lawyer, or vice versa. Hearing should be measured in hours, not days or weeks. Judges must not reject a weapon which Parliament has intended to be used for the protection of those injured by the unjustifiable conduct of the other side's lawyers, but they must be astute to control what threatens to become a new and costly form of satellite litigation. And obviously the particular phrase there that I rely on is where his lordship says that the court cannot imagine circumstances in which an applicant for wasted costs should be permitted to interrogate the respondent, or vice versa. And that, in my submission, is not simply a proposition that's there, that's merely asserted there, although such an assertion would be powerful in itself. It's obviously part of how the wasted cost jurisdiction should work in a fair and proportionate way. And although in that passage his lordship doesn't discuss privilege, a little earlier in the judgment, and I will just show the court this at the bottom of page 236, I won't read this aloud, but because the principles are so well known, it makes the point that a respondent, where it's the other side seeking wasted costs, the privilege is not the respondent lawyers to waive, and essentially every allowance must be made, is the point that's been made there. But of course the Court of Appeal, throughout what it said, was acutely aware of the issue of privilege, and there's an obvious, unless one is very careful, and I don't say in appropriate circumstances it can't be done, but there is obviously a risk at putting in the box a solicitor who has not been released from privilege and letting the other side's lawyers cross-examine him. it would have to be very carefully controlled if it was ever allowed. And I also, this next case is actually not in the authorities bundle, it's in the substantive bundle. I just go to it because it underlines the point I've just endeavoured to make. It's called Brown and Bennett. It's in the authorities, it's in the underlying bundle. It was attached to one of the skeletons below at tab 11. And page number in the new bundle is page 114. It's paragraph 185. I'll just find the old page number.
Don't worry, I've got it.
It's page 110, or yes. And this is Mr. Justice Norberger saying at paragraph 185. And it's the bit at the top of page 115 or 111, just below letter A, where he's looking at the issue of cross-examination. And he says, of cross-examination of the counsel for the other side, Abrahamson, that would almost certainly be inappropriate in the light of what's said in Right-Houge. Secondly, the exercise would likely be fruitless. Thirdly, it's difficult to see how cross-examination could proceed without quickly descending into privileged territory. And that's really what I'm going to read from that authority. I mean, those points are, I would suggest, powerful, but also obvious, but no less powerful for being obvious.
Is the Harley and MacDonald's reference of any assistance?
I'm afraid I don't. My lord, I'm sorry, I don't have that authority in the bundle. I can see if I can track it down. I apologise for that.
All right. Well, if you don't know the answer, we can look at it.
I'm afraid I don't. The cases that were before the Mr. Justice Saini, there was the Radcliffe, Deuce and Gamma versus Binns, which was referred to, and also Godfrey Morgan solicitors. I'm going to take them in chronological order. The Radcliffe Deuce case, which is at tab 2 of the authorities bundle, is the first of two decisions of Presidents of the Employment Appeals Tribunal. This is the decision of Mr. Justice Elias when he was President of the Employment Appeals Tribunal. And what had happened here was that the respondent employer had applied for a wasted costs order against the claimant's solicitors, essentially on the basis they ought to have appreciated that the claimant's claim was hopeless. The particular reason why it was said to be hopeless is that it said the solicitors ought to have appreciated that the claimant's case on having the requisite continuity of employment had no real prospect of success. It was an unfortunate episode before the tribunal, who, in fact, before the employment tribunal, they had looked at the wrong rule and had made an order essentially against the solicitors on the same basis as you can make an order in the tribunal against the claimants, essentially unreasonable conduct. And they were looking at the wrong rule. And that problem with the judgment below is referred to by Mr. Justice Elias at paragraphs 9 and 10 on page 3. He says that approach was wholly misconceived. There is a fundamental difference between the scope and application of the two sets of cost rules. That's to say those against claimants and those against solicitors. Cost orders, or preparation time orders, which broadly apply where the successful party is not represented, are made against the unsuccessful party in certain circumstances, including where the action is misconceived, which includes where the case has no reasonable prospect of success. And then he goes on to refer to what was the correct order to have been looking at for wasted costs against the solicitor in the employment tribunal. And it's very similar to the CPR rule. And he refers to Right-Houge and some other cases. And then he says at paragraph 14, the employment judge did not have her attention drawn to these authorities, nor did any of the parties identify the error that she had made in focusing upon the wrong rule. Nobody had their eye on the ball. As a consequence, she also adopted the wrong procedure. She allowed the respondent solicitors to submit comments upon the appellant's representations to her. That is not an appropriate procedure to adopt when a wasted cost order is made. The tribunal should give the representative a reasonable opportunity to make oral or written submissions as to why the order should not be made. But whilst the other party may apply for an order, though the issue can exceptionally be raised by the tribunal of its own initiative, is not thereafter comment on the submissions, and it will never be appropriate for the receiving party to cross-examine the representative against whom the order is considered. So I appreciate this is a judicial rather than a statute, but again it reinforces, having just referred to Ridehouse, the principle set down in Ridehouse that it is wrong in principle for a respondent representative to be cross-examined by the opposing party.
But that's obiter, isn't it? I mean, it seems to be on the face of it.
Yes, it is, yes.
And as well as being obiter, we see in the fourth sentence, she allowed the respondent solicitors to submit comments. That's not an appropriate procedure. That has to be an appropriate procedure, potentially, doesn't it? I mean, it seems most remarkable if the parties aren't allowed to comment on each other's submissions.
Yes, I think it was. I think I understand the point there. I think the issue there was giving them the last word. I think this is being done on paper. Yes, I think I do take your lordship's point that as a broad proposition that would be difficult for me to support. But if one looks at paragraphs 5 or 6, it's talking about various a detailed reply. Solicitors did not attend. Having dismissed the claim, the tribunal gave the appellant's notice as to why wasted cost orders should not be made. Various representations were made to the tribunal by the appellants as to why they had not acted unreasonably. There was a very detailed reply by the solicitors for the employers. So I take that.
I mean, it seems the most extraordinary if they weren't entitled to say why they disagreed with the solicitors.
I would interpret that as meaning where it's dealt with on paper, it's not right to give the applicant the last word. But I accept if it's a broader interpretation of that, then I would have some difficulty sustaining it. The case on which Mr. Justice Saini relied, putting matters differently, and we may see some of what your lordship's just put to me in this, was the decision of Mr. Justice Underhill when he was president of the Employment Appeals Tribunal in Godfrey Morgan. And that's the next tab in the authorities bundle. The facts there were that the claimant's solicitors had asked the claimant for funds to instruct counsel. However, the claimant believed he wouldn't have to pay anything because his solicitors were on a contingency fee agreement and he couldn't pay for counsel's fees. The solicitors didn't tell the employer that the claim was being withdrawn until only a few days before the hearing, after which the time for complying with various interlocutory orders, various directions, had expired. Now that led to a hearing at which both the claimant and the solicitors were cross-examined, and the solicitors were found to have been unreasonable in various respects, and they were ordered to pay wasted costs from the date on which it had become clear that the claim was incapable of settlement. On appeal, Mr. Justice Underhill allowed the appeal against the wasted costs order. And again, he then said on cross-examination, although, and I'll come to the very words, it was generally inappropriate. It was acceptable.
Sorry, you say he allowed the appeal, but the head note says he dismissed.
I'm so sorry. I'm sorry. He dismissed the appeal. Forgive me. I'm so sorry. Couldn't have been more wrong. He dismissed the appeal, and on cross-examination, he said that whilst it was generally inappropriate, it was acceptable here where privilege had been waived to a different factual accounts between the solicitor and the client. So he starts that part of his judgment at paragraph 26. In fact, perhaps, especially in the light of my Lord's comments, I should go back to paragraph 24 on page 316 of the report. And in fact, the answer to my Lord Justice Newey's point about commenting on submissions is discussed in paragraph 26.
Yeah.
And it refers to another case that isn't in the bundle of Wilson's. We ventured to doubt whether it's an absolute rule. Mr. Justice Elias's observation was made in the context of a case where the solicitor against whom the order was made had not been present at the final hearing of the case and was therefore invited to make written representations as to why an order should not be made. It is easy to see why the other party should not in those circumstances be allowed the last word. In a case like the present, where the issue is decided at a hearing, some flexibility is appropriate. So that's the answer I was reaching for in response to your Lordship's question earlier. I just say this so that it isn't thought to taint what Mr. Justice error isn't thought to taint what Mr. Justice Elias said on cross-examination. Given he was dealing with an on-paper procedure, his comment was a fair one. It's just that the passage of the judgment didn't make clear its particular context or therefore limited scope.
I'd be quite troubled about that observation in the context of a paper procedure. The rules permit applications to be dealt with on paper without a hearing, either where the parties agree or where the judge doesn't consider a hearing would be appropriate. And certainly for my part, I generally adopt a procedure on paper that mirrors the procedure that would happen in court. The applicant makes their applications, the respondent makes theirs, and then there's a reply.
Well, Lord, of course, I recognise that's the usual procedure. I would say it's a bit different with a wasted costs application. I mean, if everyone's in court, it probably doesn't matter, because if anyone's itching to say anything, the judge will no doubt be fair. If there's anything worth hearing, the judge will hear it. But the danger on a wasted costs application, where essentially you have the applicant putting in, say, a statement or an application notice, and there's no pleading, so that's the case. The solicitor answers it. It's potentially invidious to let the applicant have another go after that. It easily crosses the line into a new or modified allegation, which the solicitor then doesn't have the opportunity to answer. And then Mr. Justice Underhill says, carrying on at paragraph 26, as for cross-examination of the representative against whom costs are sought, no doubt in most circumstances this will be inappropriate and or unnecessary and or disproportionate. In a case like the present, where the representative is no longer acting for the party, where privilege has already been waived, where an oral hearing has been fixed, and where the party and the representative have given different accounts of facts which may be central to the issue before the tribunal, cross-examination would seem a fair and proportionate way of helping to get to the right result.
So where he says, given different accounts of facts, in your submission, would that be contemplating witness statements? So what he's talking about here is cross-examination of the representative on his witness statement.
Yes.
He's not saying the representative is a compellable witness, even in the absence of a witness statement.
And it was on very stark facts. And can I take your Lordship back? Because just to show what this different accounts was, it's paragraph 11. In fact, paragraph 10, just to confirm, yes, he had a letter, it may have been a letter on the same, there's a letter from the claimant and a witness statement from Mr. Clegg, and skeleton arguments. And then he says, I need not rehearse the full contents of the statements, but I should summarise what the claimant said in his witness statement about the circumstances of the late withdrawal. He said that when in May 2009 he was asked to pay counsel's fees, he told Mr. Clegg there was no way I could afford it. He said that Mr. Clegg then attempted to negotiate with LP a settlement at £3,000, but they made clear, he does not give a precise date, that the respondent was not interested in settlement, and that he told Mr. Clegg on the 25th of June he, quotes, wanted to discontinue the claim. He said he repeated those instructions in a further conversation on the 3rd of July, and a message left with Mr. Clegg's secretary at a later date in July, and yet again in a telephone conversation on the 25th of July. He said Mr. Clegg was away from work for most of July and August, and that the late communication of his instructions to withdraw was squarely GM's fault. Mr. Clegg, in his statement, took issue with that account. His statement is discursive, though also short on detail, and much of it is concerned with ill-founded criticism of LP for being unwilling to negotiate. But he does say in terms that he was not given instructions to withdraw at any time until the 12th of August. So there is a stark issue there on which, incontrovertibly, privilege has been waived, and you have specific different factual accounts. So insofar as that this is an approach to be followed. It is on very particular facts, where firstly incontrovertibly privilege has been waived, and secondly you have, it will seem quite deliberately, solicitor and client locking horns on a particular issue of fact, whether phone calls were made, whether instructions were given. So it is, insofar as there's an exception, it's very narrow. It's where privilege has been waived and where there is a stark dispute. Certainly not on an issue that the solicitor hasn't addressed.
One can see, can't one, that Mr Justice Saini in paragraph 46 of his judgment
has
really worked through
He
Mr
was
Justice
excellent.
Underhill's
Yes.
list.
But respectfully, not all of the I shouldn't call it a checklist, not all of the factors, because Mr Justice Underhill didn't say he was producing a checklist, not all of the factors applied. The facts here were very different. And the particular point, as I say in my skeleton, respectfully, that the judge below lost sight of, because I can see it gets more confused when one's looking at the directorship issue, although in my submission actually there weren't differing accounts there. But the particular point that the judge respectfully seems to have lost sight of is that cross-examination and attendance for oral questioning was sought on the basis that there were issues on which the solicitor hadn't addressed that he ought to be asked questions on.
It all makes a degree of sense if one focuses on the directorship issue and remembers that Mr Hunt's counsel told the court that Mr Hunt had alleged that it wasn't his signature.
Yes.
Granted, there's not a witness statement to that effect, and the letter doesn't cover that point, but something related but different. But if there were, as it appears, an issue of fact on that issue, on that question, which was a point in issue between one of the respondents and the solicitors, then one could understand.
Yes. And that respondent didn't press for cross-examination.
No, that's your point.
That's my point.
Yeah.
If necessary, I would go on to say it would be different, but I can see how one would reach the starting point of, well, potentially maybe this is an exception.
Well, the analogy with
but
Mr Justice Underhill's case would be much closer on that view.
Yes, but one important difference here is not that the solicitor is effectively having, in Mr Justice Underhill's case, the solicitor was having to bat off his former client's evidence to avoid a wasted costs order. What's really happening in this case is that the applicants want to use the solicitor's evidence to support an allegation of dishonesty against the solicitor's former client.
Can I just explore it one moment?
It's the same point, isn't it? Just different sized aspects of the same point.
Well, it's not, as I say, at least as yet, it's not been alleged that Walker Preston forged his signature to put no fine point on it. What's being suggested, so the only proper use that could be made of cross-examining Mr Sarwar on, well, you didn't forge this, did you, is to suggest that well, it must be that the client had lied.
Can I just explore it one moment? So suppose you say, contrary to the fact that the first respondent at all stages had pressed to cross-examine, and suppose further that the first respondent, again you say, contrary to the fact, had plainly put in issue the question of whether Walker Preston's had forged the signature on the response to the Part 18 request, then it rather looks as though one might be in territory where Mr Justice Underhill would have thought the cross-examination was appropriate to some degree. If the first respondent's case against Walker Preston's is not merely that the signature was forged, but that inadequate instructions had been taken on directorship, and if, as I think you would probably accept as a general rule, once you have a witness in the witness box, you can ask them about other things relevant to your case.
Yes, although the court can control that.
The court can control it. But if you get that far, why is it right for the court to control those further questions when the normal principle is that if somebody's giving relevant evidence and you're entitled to cross-examine, you can cross-examine about other aspects of your case?
As your lordship says, I would say...
You say it falls down at various ends.
The answer here must be privilege.
So just, can we explore that a moment?
Of course, my lord.
come an effective hearing, you presumably have Mr. Hunt there responding to the fundamental dishonesty allegation. And suppose when he's in the witness box or at some stage prior to Mr. Sarwar going into this witness box, he says, well, I'm waiving privilege, that's fine. What happens then?
Well, this comes, in my submission, it would come back to what Lord Bingham said about this being a summary, firstly about this being a summary procedure and not a source of satellite litigation, and secondly, fairness to the solicitor requiring the solicitor knows what allegations are being made. What wouldn't be permissible, in my respectful submission, is for things to, Mr. Hunt to say that on the day, stuff, material to come tumbling out, and then Mr. Sarwar is expected to deal with that on the hoof. That's not, he hasn't had a fair opportunity to consider the allegations being made if that happens.
So can we just pause a moment? I mean, in general terms, I can see the sense of that because Mr. Sarwar is then having to respond to worse than a normal solicitor's negligence claim without any of the normal protections.
Yes.
But at the same time, in this scenario, you have the judge having to determine the fundamental dishonesty point. And he also has before him the wasted costs applications. He's got Mr. Sarwar giving evidence, and he says various things. How is he to deal with that? I mean, he has to determine whether there was fundamental dishonesty. That presumably involves taking a view on Mr. Hunt's evidence, which may explicitly or implicitly involve taking a view on Mr. Sarwar's evidence.
Well, yes, if Mrs. It would, yes. I mean, I can see there's an overlap in the applications there. I mean, I would say ultimately it comes back to, although I appreciate it's in authority rather than a statute, what is, and here respectfully I would say that a solicitor should not be, a solicitor should not be cross-examined on a wasted costs application, and a solicitor should not be cross-examined, and I know this is a different point, for the purposes of supporting a dishonesty allegation against the solicitor's former client.
It may play out differently. Mr. Hunt's answer to fundamental dishonesty may be, look, it's all Walker Preston's fault. They acted dreadfully. So the judge in determining Mr. Hunt's liability may really be determining Walker Preston's position.
But, I mean, it's the applicants who have chosen to make a two-pronged application. And they've not suggested any kind of, but they wouldn't, I mean, my answer to that is they wouldn't, whatever Mr. Hunt says, they wouldn't at the hearing be entitled to add new allegations to the application for wasted costs against Walker Preston.
How do we know that Mr. Hunt is going to attend the hearing? And how do we know that he will give oral evidence even if he does? Because presumably he's not a compellable witness either. If by that time he's taken some legal advice, he withdraws his letter.
He may well not. I mean,
simply relies on submissions.
He may well be well advised. Of course, we don't advise, but he may well be well advised not. Even if he's represented, not to submit evidence. He may well not do that. We don't know that he would do any of that.
But that rather highlights a point that's troubled me throughout this. You've pointed out that the order itself doesn't say what everyone thinks its effect is. One possible interpretation of what was said is that Mr. Sarwar should attend so that he is there if cross-examination, and to the extent that cross-examination is appropriate in the circumstances that then prevail. That may be, seems to me, what the judge intended and what Mr. Justice Saini thought he was dealing with, because, as you point out, Mr. Justice Saini didn't rule that privilege had been waived. Well, that's at least an interpretation of his judgment. He took it that privilege might have been waived, but Mr. Hunt had the options open to him if and when he turned up. And if that's it, just to follow that through, if that was the effect of the order, unstated and unspecified, then it may be a procedural nightmare. that's been produced, but that's not your point. Your point is that he shouldn't be exposed to cross-examination. That decision on this analysis has yet to be taken.
My lord, it may be if your lordship's right, this appeal has been a storm in a teacup, maybe.
Or premature.
Premature. Firstly, although I recognise that the wording the circuit judge used, if one looks at the transcript, I say it is clear, and indeed the word cross-examination is used in the transcript. And that's also the basis, certainly the basis on which it was dealt with before Mr Justice Saini, where he does in I think it's about the first paragraph of his judgment, he does refer to it being an appeal against an order for cross-examination. I hope I'm not overreaching when I say that without the judgment in front of me. Let me just turn it up. Yes, paragraph 1 of Mr Justice Saini's judgment on page 37, I think, of your lordship's bundle, 33 of the old bundle.
And if that's how Mr Justice Saini saw things, then when he comes effectively to exercise the discretion de novo,
then he is exercising on that basis, undoubtedly.
Yes.
I think
Well, he does. What he actually says is an order that Mr Sarwar attend the hearing in order to be cross-examined. It would be a hard, unusual thing to say, you're going to be cross-examined and I'm not going to control what questions are asked and what you have to say. Suppose Mr Sarwar turned up and questions were asked which went into privileged matters, and he said, well, I'm not answering that because it's privileged and my client hasn't waived privilege. The orders that have been made so far don't foreclose that.
They don't, sorry, my lord.
They don't foreclose that.
They don't foreclose. Certainly, certainly, where there's privilege, the orders don't, and I'm not suggesting the order purports to have the effect of requiring him to answer privileged matters. But it does require him to attend to be cross-examined. So that's why I say the decision has been made.
Well.
And indeed, whether we're all right or not, it's how everyone has understood it. I recognise in my skeleton when we applied for permission that the order that the circuit judge didn't say that in so many words, but that's how everyone has taken it, including the High Court judge.
Yeah.
Well, look, can I just have a... I just wanted to say, I just want to say a few more words about Godfrey Morgan. If necessary, and I say there are clear points of distinction, if necessary, respectfully, I would say that Godfrey Morgan shouldn't be followed. The reasoning is at paragraph 27 on page 317. Having quoted the well-known passage from Ridehouse that I took your lordships to a little while ago, the president of the EAT says this, that it does not say anything about cross-examination in context. The reference to interrogating the representative is clearly to administering paper interrogatories. The real point being made is that the procedure should be as summary as is consistent with fairness, and in that context, the court deprecates the deployment of elaborate procedures. It might on that basis have been open to one or more of the parties to submit to the judge that he ought not hear oral evidence at all from either the claimant or Mr Clay, and simply have made a broad brush assessment on the basis of their statements. I am not in fact sure that would have been right. It would have been right for the judge to accede to such a submission in the circumstances of this case, but the real point is that it was not made, and that all parties proceeded on the basis that an oral hearing with live evidence was required. In those circumstances, I can see nothing wrong in the evidence being tested in cross-examination. So, it seems there that the solicitor's objection to oral evidence was a complaint made on appeal after having gone along with it below. So again, that's a point. In a sense, the horse had bolted. If I'm too early, then they were undoubtedly too late. It had happened. For what it is worth, and insofar as I need to, I would respectfully submit that Mr Justice Underhill's interpretation of interrogatories as referring to paper interrogatories is too narrow, really, for two reasons. The first is, and I know that at least under the old rules, it was a term of art. But interrogate, I would suggest, is being used by Lord Bingham in a broader sense. It includes, so it would include, although it's not confined to cross-examination. But secondly, it would make no sense in principle to say, well, you can't ask the respondent lawyer questions on paper in advance, but you can put them in the box and ask questions on the day. That would not respectfully make coherent sense.
Well, doesn't it depend on whether the lawyer has put in a witness statement or not? Because there's a big difference between cross-examining a witness upon their witness statement and interrogating the witness in the absence of a witness statement.
Yes, that may make a difference, I reckon.
Because it's a fundamental principle of our system of civil justice that if people put in evidence, they can be cross-examined on it. It's not a principle of our system that people can be cross-examined if they are not volunteering evidence.
My lord, yes.
On the contrary, we set our faces rather against that.
We do, my lord, yes. I mean, I may not need to urge this point upon it, but I accept what your lordship says, of course, as a general proposition. I would say that where a solicitor puts in a statement in response to a wasted cost application, the general principle is still that the solicitor, or the principle stated by Lord Bingham, still applies, that a solicitor will not be cross-examined. Lord Bingham isn't saying he won't be cross-examined unless he puts in a witness statement. He's saying he won't be cross-examined. And I would say interrogating is broad enough to cover that.
Just, I quite follow this, may not really matter, but as to what was meant by interrogated, Mr. Justice Underhill's interpretation might seem the more plausible, since in the preceding sentence the court has referred to discovery. And in the old days, discovery was one form of disclosure, and you could supplement that by administering interrogatories.
Yes, I see, respectfully recognise force in that point. It may be that that's what led to the use of the word, but the broader principle is still that the evidence, that the solicitor won't be questioned on their evidence, in my submission, for the obvious reasons that it goes into privilege and matters of that sort, potentially. And also, it's not consistent with dealing with things simply and summarily. If one has a mini, it would turn wasted costs into a mini trial.
Yes.
Or maybe not so mini. My lords, if I can leave that authority, the final authority I was going to mention is the Stocko Partnership and Grayson case, which hadn't been handed down when we first applied for permission to appeal, but your lordships will have seen that it's specifically referred to by Lord Justice Bean when he gave permission to appeal. And the issue there was cross-examination of an affidavit sworn pursuant to a Norwich Farmer Court order. And I do accept that I can't read across the specific considerations there into the different factual situation that your lordship's dealing with. But it does serve to underline the general principle that outside trials, cross-examination of the opposing party is not generally permitted. And if I show your lordship's paragraph 17, so that there are, of course, many applications where there may be disputes of fact, interlocutory applications all the time, but they're generally resolved without cross-examination. Paragraph 17.
As you've recognised, there are difficulties in reading across, not least because the point that, as I understand it, particularly weighed with the court, was concerned that this would be cross-examination in advance of trial.
No,
there is going to be no trial.
It's the first and last day of the show, so I accept. There was a concern that it would, indeed, your lordship is right, there was a concern that it would end up trespassing, or despite assurances to the contrary, the court was concerned it would end up trespassing into matters that would be matters for trial. So I mean, I rely on, so I don't try to read across, but I rely on paragraph 17 as an accurate general statement of the principle.
Yep.
And also just perhaps paragraph, if I may, finally paragraph 31. So the judge, Mr. Justice Tipples, had made an order, but an order by consent, which included an order for an affidavit. And the court rejected the proposition, as the court says, I do not accept the submission on behalf of the appellant that once Mrs. Justice Tipples, by consent, made an order for disclosure, not merely in the form of a witness statement or the provision of further information under Part 18, but by affidavit, the door was automatically open to cross-examination on that affidavit. As noted above, CPR 32.7 is of general application. And then that goes on to say that consenting to providing an affidavit does not of itself open up the deponent to cross-examination. So the only point I draw from that is a fortiori, the making of a witness statement doesn't of itself open a deponent up to that, other than perhaps as a general matter at trial. My lords, can
I just rephrase that in my own language to see if I've understood the point? So, do I understand you to be saying that if there's a witness statement, then that provides a jurisdictional basis for an order under 32.7, but does not compel an order to be made?
Yes.
And that would seem to imply a further point, namely, in the absence of a witness statement, then there's no jurisdictional basis.
Yes.
Because 32.7 doesn't apply.
Yes, I'm not taking I accept that I've not taken a point today that there's no jurisdiction to make the order. It's a point that was pursued below that I accept what you say.
Well, that's because currently there is Mr Sarwar's witness statement, and that has not yet been withdrawn. So one has a jurisdictional basis under 32.7 to make an order for cross-examination of Mr Sarwar upon his witness statement.
Yes.
Your submission is it's not compulsory.
Yes, and my submission is for the reasons, and I won't go through it, that it's wrong in principle on these in this particular situation to do that. But your lordship is right. The corollary must be that there's no jurisdictional basis where there's no statement, and at least in theory, Mr Sarwar could withdraw that statement. So I end really where I began with your lordship, that actually this is best understood as an order that he come along to answer questions regardless of his statement. And that's most clearly demonstrated by the fact that the basis on which the order was sought and made was that he hadn't dealt with certain matters and he needed to be asked against them.
Yeah.
My lords, could I just have a moment?
Yes.
Well, my lords, unless there's anything I can insist further on at this stage, those are my submissions.
Mr Aurora.
Lords, if I may, I would propose dealing the opposite way to that of my learned friend Mr Marvin by starting with the authorities. And your lordships have 4 authorities in the authorities bundle. And dealing with them again in the reverse order, the Stokoe Partnerships case, I think my learned friend is quite right to concede that this doesn't assist greatly in terms of a wasted costs application. It is quite specific to the jurisdiction concerning Norwich Pharmacal orders, and in particular there is reference at several places to the just and convenient test, which your lordships will know is the relevant test under that jurisdiction. But I think, as my lord noted, there is quite a pressing point, which is that the decision of Lord Justice Bean was largely premised on the fact of cross-examination, preempting cross-examination at trial, and that's paragraph 7 of the Court of Appeal judgment, my lord. The judge's first and, brackets as I see it, principal reason for refusing the application was the one given in para 40 of the judgment, that cross-examination on the affidavit would preempt cross-examination at trial. And I think if over the page, paragraph 13 of the Court of Appeal judgment, there is a subheading at the bottom, cross-examination of a defendant prior to trial. Although the judge gave 4 reasons, or as he described them, difficulties, which led him to refuse the claimant's application, the most important by far, and the one which, if I may say so, justified the grant of permission to appeal to this court, was the first, which is the question of preempting cross-examination at trial. Now that, of course, is very unlikely ever to arise in a wasted costs application, but particularly in this case, simply cannot arise, because the trial, as we all know, was aborted in light of a decision by the claimant to discontinue at the 11th hour and 59th minute, I think I put it on the day. So there is no question of any trial cross-examination being precluded by this. And indeed, as my Lord indicated, what this case is saying is that under 32.7 there is a power for cross-examination trial. It doesn't necessarily follow that cross-examination will be required in every circumstance. And if I could posit an example of one in which it wouldn't be appropriate, it would be, for example, one where privilege was clearly not being waived by a claimant. The claimant was in lockstep with his former solicitors or even current solicitors. And the solicitor's statement simply referred to privilege and said, I can't say anything more. Well, in that circumstance, there may well be a witness statement. 32.7 may well apply, but it wouldn't be the case that cross-examination would follow as a matter of course. But, my Lord, that is not this case. This is a case in which there is clearly a dispute between Mr Hunt and Walker Preston's. And I think Mr Justice Saini encapsulated it in a section of his judgment that my learned friend Mr Marvin did not refer to, as having page 41 of 290, Lords, paragraph 28 of the judgment. I described what Mr Hunt is there doing to Walker Preston's as effectively, quote, throwing them under the bus. Counsel before me did not dissent from the description. If I recall correctly, I think Mr Denton and I referred to both parties trying to throw each other under a bus. But clearly, that is a situation that is very different from the Stokoe partnership case, in which presumably the solicitors and the party being the party whose cross-examination is sought is still going to be a live witness at the trial. There is also, my Lord, I think at paragraph 42 on page 8 of the judgment in Stokoe at the top, there was reference to Mr Robinson being cross-examined. And my note in the margin refers to, well, was Mr Robinson going to be cross-examined anyway, in the way that Mr Hunt will be? Because Mr Hunt needs to attend and be cross-examined in order to justify himself in relation to fundamental dishonesty. And that, I say, is a very important point on the facts of this case. And I think the answer to my hypothetical question is given...
Why should we assume that Mr Hunt will give oral evidence?
The approach that he has taken, my Lords, that he's presented his letter to Judge Godsmark, attempting to justify his
I presume
his
you
conduct.
would accept that letter is plainly written without the benefit of legal advice.
I understood, my Lord, that it referred to a admin at injury law firm or something of that nature. If I could find the relevant page.
I think it's 78 of the supplemental
It's
bundle.
clearly, yes, my Lord, I'm grateful. It's clearly not been written by a lawyer. Yes, I accept that point, my Lord. But I understood he was referring to...
It's the handwritten bit on page 78.
Yes, admin injury law chambers. Those who instruct me were under the impression that he was seeking a form of advice, and indeed he was enjoined to do so by His Honour Judge Godsmark.
Well, he might have been seeking advice.
Yes.
But the question is whether his letter was written with the benefit of legal advice. Now, of course, we don't know.
No.
But would you accept that on the face of it, it seems unlikely?
Quite probably, my Lord. But having said that, in terms of the substance, it does appear, I would say this with respect to him, to Mr Hunt, it does appear to be making the relevant points that one would have expected from somebody who had considered their position, because he describes he throws Walker Preston under the bus, in the words of Mr Justice Saini.
Well, does he? I mean, he accuses them of being negligible.
Indeed.
But what in substance does he actually say that they've done wrong?
That they ill-prepared counsel for his trial.
And how does that amount to fundamental dishonesty?
Well, my lord, I probably have to take a step back in relation to this and the fundamental dishonesty point, because the allegation was made that he had been a director. That was asked through Part 18 questions, I think, in May of 2019. The response comes back, no, I was never a director, signed. And there is a dispute, of course, about the signature on that document.
You say that, of course, there's a dispute. Are you alleging it was a forgery?
My lord, I don't know, is the short answer to that. I've given some thought in relation to that because you asked my learned friend, Mr Marvin. The fact is that the claimant said very clearly at the trial, the aborted trial before Judge Godsmark QC, that he did not sign it. That does raise a question of who did. Now, without anything further, I cannot say that somebody at Walker Preston's did sign it. But it does raise a question of, in respect of the wasted costs issue, from Walker Preston's to have put forward the document as being signed by their client when he denies ever signing it, that potentially could be improper or unreasonable conduct. For Walker Preston's to have acted without instructions in relation to that document could potentially fall into that category. And it's not therefore necessary for me to show that it was a forgery in order to maintain the wasted costs allegation against Walker Preston's.
Can I just break that down a moment? One thing we do see from Reithold is that the solicitor has to be clearly told what's alleged against him. Here, you're raising as a possibility an allegation that a solicitor forged something, which is a most serious allegation. Now, in those circumstances, I don't think it's open to you to sit on the fence. I'm not suggesting you should answer this moment, but I would have thought by 2 o'clock you should. You need to say whether, as part of your wasted costs application, you are alleging that Walker Preston's forged Mr Hunt's signature. Now, that isn't the whole of your application, as I understand it. As I understand it, and tell me if I'm wrong, either now or at 2 o'clock, the overarching allegation is that Walker Preston's failed to obtain proper instructions on the issue of being a director.
That's paragraph 8, isn't it?
That's paragraph 8.
Yes. My lord, paragraph 12... Oh.
Sorry, go on.
Well, paragraph 12, which was the other paragraph that your lordship took Mr Marvin to, does say, 4 lines down from the top of page 7 of 95, I await evidence from Walker Preston's in this regard, but if the replies were signed without the claimant's knowledge, then unnecessary time and cost have been incurred in this claim, which was the fault of whoever signed the replies without knowledge of the claimant, if that is indeed the case.
So I need to know, I think the court needs to know at 2 o'clock, whether you are alleging, I mean, you may or may not prove to be right, but I think we need to know, Mr Sarwar needs to know, whether you are alleging that Walker Preston's forged the signature.
Well, my lord, I will have to revert to you at 2 o'clock.
And that, of course, would include applying the signature without authority, because that's one way of forging it.
Yes.
Because I don't think it's satisfactory to leave a solicitor in doubt as to what is alleged against him, the more so when it's such a serious allegation.
Well, my lord, I would have to revert to you at 2 o'clock in that case. But returning to the point on the appeal, the question is not whether this application on wasted costs is likely to succeed when it does come back before Judge Godsmark QC. The question is whether there is a blanket prohibition on solicitors being cross-examined in relation to that.
I just had this rider. If it were the case that no one was alleging that the signature had been applied without authorisation, then Mr Sarwar could withdraw his witness statement.
But Mr Hunt has made that allegation in court through counsel.
But it's a matter. Well, I suppose Mr Sarwar would have to take his work out his position in relation to Mr Hunt. But what he has done so far is put in a witness statement in response to your application. If it proves to be the case that you aren't alleging, and potentially Paragon isn't alleging, that the signature was applied without authorisation, then presumably Mr Sarwar doesn't need to deal with that topic and can withdraw the witness statement.
The important point, though, in relation to this particular case, my lord, is that there is something of an excluded middle from Mr Hunt's perspective, because if he did in fact sign that document, it points directly to fundamental dishonesty, and it's difficult to see how it can be escaped from in that circumstance. If he didn't, then it raises the question which he himself has raised, and I say that the defendants are entitled to run with effectively once it's been raised in open court, to say, well, somebody must have signed it.
Yeah, I'm not saying you can't run it.
No.
But if you're going to run it, you have to say so explicitly, and then you have to live with the potential consequences of running such a serious allegation.
Which is why, my lord, I will have to take instructions on it.
Yes, no, I follow that.
Certainly.
And bearing in mind that Mr Hunt's letter does not make any such allegation at all, but seems to be talking about something completely different.
My lord, I was listening to my friend Mr Marvin's comments in relation to that. I'm struggling to see it because I didn't see anything on the company's house documentation that was signed. And
I would think
Mr
there
Hunt
was.
says in terms, the document was one that I had allegedly signed which made me a director of the firm National Glass.
yes,
That can't possibly be the response to the RFI. It must be a different document.
well, the Part 18 response, my lord, does say I was not a director.
I mean, just exploring this a moment. I mean, you would expect Companies House to have on their file a document signed by the person appointed as a director.
My lord, yes, but because I remember this at the trial, the aborted trial. That was not the essence of our position. The point raised, and if we go back to the first Part 18 response,
Yep.
where it says very clearly that is my name, that is my date of birth, but it's not me.
Yes.
That was the position taken by Mr Hunt in the Part 18s. As your lordships will be aware, noise-induced hearing loss trials typically have the full medical record. And remember, the night before the trial, I went through the full medical record, and the address for Mr Hunt on his former medical records matched identically to that of the company's house address. And my lord, that was the point, I think, that I raised in a skeleton argument that I prepared and put to counsel the next morning when she arrived and said, well, what do your client say about that, effectively? And it's after that position that this position was adopted by Mr Hunt. So, my lord, I could be mistaken, it was nearly 2 years ago now, but I don't recall there being a further document.
I mean, I can't remember how far Companies House records go back. I suspect they covered this. I suspect if you looked on Companies House, you would find filed on Companies House a document showing the purported appointment of Mr Hunt as a director.
I'm sure there would be, my lord, I don't doubt that. The question is whether that document was put to Mr Hunt as being the reason for him changing his mind effectively about the Part 18s.
But that doesn't seem to be what the lesser is talking about. This seems to be before the Part 18 is put in, probably. So Mr Meachin, Walker Preston's, says, look, I've seen this signature on the Companies House document, is my hypothesis. And he says to Mr Hunt, well, is it really your signature? And Mr Hunt says, well, he can't recall signing it.
But this discovery by Mr Meachin isn't mentioned in Mr Sarwar's statement, I don't think.
No, that's because Mr Sarwar is addressing the response to the Part 18 request, which is a different topic.
Well, he's addressing the allegation of wasted costs in relation to that, my lord, yes.
I mean, it may be that what happened was that Mr Meachin had this discussion with Mr Hunt about the Companies House document. Mr Hunt thought he hadn't signed it. Therefore, Mr Meachin thought it was all right to prepare a response to a Part 18 request saying that Mr Hunt hadn't been a director. Mr Hunt signed that electronically during the pandemic, producing a signature unlike his normal signature.
Well, I'm not sure the pandemic is...
Well, it's relevant
It's
to
a
the
year
sense.
before the pandemic, unless I'm mistaken. It's May
Oh, you're
2019. The pandemic is March 2020 onwards.
That does make sense.
Unless I'm mistaken.
No, you're sure you're right.
Well, putting the short of it together, my lords, the answer is that there is a factual dispute in relation to this between Mr Hunt and his former solicitors. And that is something which draws us out of the context of the authorities on which my learned friend relies, and draws us very much, I would say, into the context of the third authority in the bundle, which is the Godfrey Morgan solicitor's case. Because much as Mr Justice Saini's judgment effectively lifts the reasoning of Mr Justice Underhill, that, my lord, I say, is the correct response, the correct interpretation of the law in this area.
So, can I ask you this question? Do you submit that a solicitor is a compellable witness at the instance of a party seeking a vested costs order in the absence of a witness statement?
My starting point, my lord, would be that a solicitor is an officer of the court, and that I say takes them out with the position of, say, the respondent in Stokoe Partnership, Mr Grayson, I think it was, who is not. A solicitor of the court owes a greater duty and can be ordered by a judge to attend for reasons. But in this particular case, the fact is that Mr Sarwar's put in a witness statement, and that is what renders him open to being compelled.
Right, so you would invoke the jurisdiction conferred by 32.7 to cross-examine a witness upon their witness statement?
Lord, yes.
So what if the witness statement is then withdrawn? Do you accept that in those circumstances there could be no cross-examination?
My lord, I confess that's not a point that occurred to me before today, because of course the statement hasn't been withdrawn by Mr Sarwar. In circumstances where, and this is in some way bringing us back to the original telephone hearing before His Honour Judge Godsmark, not only has a witness statement been ordered by the judge to be put forward, but also no objection was taken to Mr Sarwar attending for cross-examination. Indeed, counsel for Mr Sarwar's firm appeared to indicate that it was the proper way. Then that brings us back, my lord, to the point about discretion. And when my learned friend Mr Marvin said that there needed to be a respondent's notice in relation to this issue, respectfully I disagree with him, because the fact is that Mr Justice Saini has applied two angles in relation to this. The first is, well, Judge Godsmark was plainly within his discretion to order this, and in light of not only no objection but positive acquiescence from Claimant Solicitors Counsel, that was a case management effectively decision which was open to him. And this was the point I did raise in the skeleton argument, the early part of the skeleton argument. But also 32.7 as an alternative, both routes, my lord, lead to a situation where Mr Sarwar can be called for cross-examination.
And what do you say to the point? I'm sorry, I may need to back up and just allow you to develop your submissions, but of course there was no application notice. And indeed, on the day, you didn't ask for cross-examination. So what do you say to those 2 points?
In relation to the latter, my lord, I have to hold my hands up and say I should have expressed myself more clearly, because what I did do, quite obviously from transcript and from my own memory, was refer to Mr Denton having more pressing concerns. In relation to an application notice, my lord, it was listed for case management in relation to that, because we were due to have a final hearing. That couldn't go ahead because Walker Prestons was still on record as acting for Mr Hunt, notwithstanding they had been prompted about this issue. And Judge Godsmark QC was entitled to use a hearing as a case management hearing and set direction. So it was not an out with his discretion.
So he had carte blanche to ambush Mr Trevelyan, did he?
Lord, it's not. Well, it's not an ambush, my lord, to say. This is a matter that requires cross-examination of not just Mr Hunt, but also Mr Sarwar. So, Lord, I don't accept the characterisation of this as an ambush. I'm trying to recall, my lord, if the initial discussion of oral evidence concerned Mr Hunt or if it concerned Mr Sarwar at first.
it starts at page 5 of the transcript, doesn't it? Which in my bundle is page 235 of the bundle, but won't be in yours.
247 in mine.
Yep.
As I read it, when Judge Godsmark raises the question, it's directed solely to Mr Sarwar. And then he comes back to you. What I want to know at the moment is, do you require Mr Sarwar for cross-examination? And your response is, Your Honour, I think I would be prepared to deal with this without him being present. So the judge is focused on Mr Sarwar, not Mr Hunt, and your answer is you don't require him.
My Lord, yes. Having first said, I think my learned friend Mr Denton has stronger views on that than I do, Your Honour, yes.
Yeah, because you knew that Mr Denton was going to apply for cross-examination.
Yes. That doesn't, my Lord, whether, well, I still will not accept the characterisation of it as an ambush, because it is a case management discussion in relation to this, and counsel for the solicitors did have the option of saying no, and equally, my Lord, that the page 6 of the transcript in relation to the very last comments from Judge Godsmark and Mr Trevelyan. I think what we need to do today is give directions that will ensure opportunity for Mr Hunt to become engaged and look for a hearing date the parties can attend to give evidence. And then that's said to be the view of the landscape of the learned judge. Mr Trevelyan is given his opportunity to respond, and Mr Trevelyan agrees. It wasn't necessary for Mr Trevelyan to agree with Judge Godsmark at this point. But it must have been anticipated to some degree that oral evidence would be required because of, this is the point I'll keep returning to, my lords, because I do say it's important in the context of this case, because of the question about fundamental dishonesty, which would require an oral hearing of some nature.
Well, it depends what you mean by an oral hearing. Not necessarily oral evidence, but if you look at page 6, just above the passage you were referring to, Judge Godsmark says this: so the position is that even if Mr Hunt himself decides to play no further part in this matter, we're going to require some live evidence in any event. And then he goes on to the question of privilege. So the judge seems to be contemplating that he's going to require evidence from Mr Sarwar even if Mr Hunt plays no further part in the proceedings.
That does appear to be what Judge Godsmark was thinking, Your Honour.
And do you defend that?
At this point, my Lord, has there been an order in relation to witness statements proposed? I don't think there had been.
Well, there was the prior order.
My Lord, I think, is this not also though referring back to the comments of Mr Denton in respect of the medical evidence issue, Mr Zaitoon? Because if I've understood Mr Denton is saying there, that, as I understand it, my Lord, is not part of my primary case in relation to that.
So you say that's a point for Mr Denton?
My Lord, yes.
Okay.
I think it is.
Essentially 1 o'clock. Is this a convenient moment to break?
I'm in your Lordship's hands.
Let's do that.
All rise.